Welcome to everyone. We've got about 340 people registered to attend today, which is great. I'm delighted to have you join us for the first in a series of more than 10 webinars on our recently released report on the National Inquiry into Sexual Harassment in Australian Workplaces. Each webinar will be focused on different stakeholder groups. Today's law reform focus is particularly important as we want to circle back to many of you who contributed in submissions and consultations and who will play a critical role in implementing our recommendations. I'd like to acknowledge the traditional lands of our nation's First People. I'm presenting from the lands of the Wurundjeri and Boonwurrung people of the Kulin Nation. I invite you to take a moment to pay your respects to the traditional owners of the land that you are on. Please be aware that this session is being recorded and will be available to share with others in the next week. I'm mindful that people listening to this webinar may find the content distressing, so I remind you that there are support services available should you need them, 1800-RESPECT and 000 if you're in immediate danger. I thank participants for posing questions ahead of time. You can send through questions anytime using the Q&A function, either to the right of your screen or on the bottom. The icon looks like a text message chat. The Q&A is pre-moderated, so there may be a short delay before your question appears publicly. I remind you of the importance of remaining civil throughout. During the webinar, participants will be muted, and I would appreciate for you to keep the mute setting on during the session. Participants can also turn on live captioning if you require via your settings, which might be by clicking on the three dots on the top right of your screen or at the bottom, and then you choose Turn on Live Captions. Now to introductions. Many of you will know that I'm the Australian Sex Discrimination Commissioner. I started in this role in 2016 and have worked on a number of significant projects of the Australian Human Rights Commission since, including with defence, universities and Play by the Rules. More importantly, I had worked for 20 years as an employment lawyer specialising in the area of workplace sexual harassment. And it was in that role in the 1990s that I first met my co-presenter today, Kate Eastman, when she was the legal officer at the Australian Human Rights Commission. I know you've been busy since then, Kate, so could you please introduce yourself now?
Oh, hello, Kate, and hello, everyone on the webinar today. What a privilege it is to be involved and for the first webinar. So Kate is right, we met many years ago when I was counsel assisting the Human Rights Commission into an inquiry on sex discrimination. So since then, I've gone on to be a barrister practicing in New South Wales, but also working around Australia in a range of areas, including discrimination, employment law, public law, and a range of royal commissions. So thanks, Kate, for having me. I also pay my respects to the Gadigal people of the Eora Nation, on whose land I'm attending today.
Thank you, Kate, and we'll look forward to hearing from you next. Throughout the inquiry, I was privileged to hear from many Australian workers, from victims of sexual harassment and harassers, from co-workers, union reps, managers, from family and friends, and those stories had a big impact on me. One experience that has really struck with me was one shared by the husband of a woman who'd been sexually harassed in the workplace where they both worked, and who had tried to navigate the complaint systems both within the workplace and through the legal system. He described with disillusion the cover-up when she raised her complaint, the victimisation that followed promptly afterwards, the fear that stopped any witnesses coming forward to support her, the conflict of the self-managed complaint process of the managers, her distress when her complaint was rejected after the investigation, the inadequacy of the escalation avenues through the public service, and the battle through a legal process against an agency with seemingly unlimited funds, which used tactics that he described as the 3Ds: distract, delay, deny. He described multiple failings culminating in a David and Goliath battle, which 10 years on still affects his wife, family, and working life. Paul came to our consultation to represent his wife, as she was not fit to do so. But in reality, he powerfully shared the impact on him as well as their 2 sons. He described that his wife had been devastated. He told us, "I've had to stop her taking her life." He told us how he had supported her while raising their sons and how sad he was that their sons had never known the happy woman that he had married. And it struck me how hard it must have been while this was his employer too. We commenced the national inquiry in 2018 with the support of government, unions and employers, and off the back of the global Me Too movement, which placed a renewed spotlight on the prevalence of sexual harassment at work. The goal of the inquiry was to examine the nature and prevalence of sexual harassment in Australian workplaces, its drivers and measures to address and prevent it. Respect at Work is the culmination of 18 months of work, involving a survey of 10,000 workers, 60 public consultations with 600 participants, 460 written submissions, global research and economic modelling. I launched Respect at Work alongside the Minister for Women, Senator the Honourable Marise Payne, on Friday the 6th of March 2020. Minister Payne and the Attorney General, the Honourable Christian Porter, welcomed the report and said the Australian Government will carefully consider its recommendations. They also underlined the Government's commitment to ensuring Australian workplaces are safe and free from sexual harassment. A quick refresher, this is the definition of sexual harassment under the Sex Discrimination Act. At its simplest, sexual harassment is unwelcome conduct of a sexual nature, which reasonably causes the person harassed to be offended, humiliated or intimidated. Our inquiry focused on sexual harassment at work. Our survey told us that the most common types of sexual harassment were sexually suggestive comments or jokes and intrusive questions about your private life and physical appearance. I often refer to these as everyday sexual harassment. Sexual harassment was the overarching feature of my work experience as a young woman. In all of these workplaces, the managers or owners either perpetrated sexual harassment themselves or were aware that it was happening and did nothing to prevent or respond to it. Sharing these experiences with my female friends, I know that my experience is not singular or extreme. This is, in many ways, an unremarkable story. This quote reflects the spirit of what we found through our inquiry. Firstly, sexual harassment is a common experience. Our survey and inquiry told us that workplace sexual harassment is pervasive. It occurs in every industry, in every location, and at every level in Australian workplaces. In 2018, 1 in 3 Australian workers had experienced workplace sexual harassment in the last 5 years, up from 1 in 5 workers in 2012. Sexual harassment was experienced by 39% of female workers and 26% of male workers. Young people were at the greatest risk. 45% of people aged 18 to 29 years were harassed in the last 5 years. And LGBTI community, people with disability, Aboriginal and Torres Strait Islander workers, and migrant workers were also at highest risk. We found the onus has been on the victims to complain. Yet we found that only 17% of people who said they were sexually harassed at work made a complaint. People said they didn't want to complain because they feared for their jobs, reputations and families. They feared the brutal complaint processes, and they thought that people would think they were overreacting, or they would not be believed, or nothing would change even if they did raise it. Basically, Australian workers don't want to complain. and particularly they don't want to get involved in a complex legalistic investigation process. They just want it to stop. Thirdly, we found that sexual harassment happens in all workplaces. Our 2018 survey collected industry-specific data for the first time across 21 ABS-defined industry sectors, which provides a valuable resource for industry action. Our workplace chapter highlights that collective industry action is critical to reducing sexual harassment as a systemic issue. In the report, we identified that some industries and some settings create a higher risk of sexual harassment, including male-dominated industries like construction and mining, industries that are organised according to hierarchical structures like police, defence, medicine, law and academia, and industries with high level of contact with third parties like customers, clients, diners, patients. So that includes retail and hospitality and health and social assistance sectors. We also heard that sexual harassment happens in rural, regional and metropolitan settings, as well as in small, medium and large workplaces, although workers in larger organisations are at higher risk. And finally, we heard that sexual harassment has a high cost. The inquiry allowed us to give voice to the extent of mental, physical, economic and other consequences of sexual harassment for victims, workplaces and the economy. Economic losses are staggering. Deloitte Access Economics modelled the economic costs of workplace sexual harassment, and they estimated that workplace sexual harassment cost the Australian economy $3.8 billion in 2018. This is Australia's opportunity to instead invest this money in effective prevention and response initiatives for better health and economic outcomes for its workers and workplace. Overall, we heard sexual harassment is a systemic problem rather than a matter of a few individual misconduct cases caused by a few bad apples who are misbehaving. The key power disparity driving sexual harassment is gender inequality along with intersectional disadvantage. The current system for addressing workplace sexual harassment in Australia is complex and confusing for victims and employers. And we need to shift from the current reactive complaints-based approach to one that requires positive action from employers and a focus on prevention. Most positively, we heard that Australians have a strong appetite for change. Our report therefore proposes a new approach which builds upon Australia's existing policies and initiatives through 55 recommendations which fall under 5 areas of key focus. Firstly, data and research to deliver useful industry-based information about the nature of sexual harassment and effective actions. Secondly, primary prevention of sexual harassment through education, media and community-wide initiatives. Thirdly, a refocused legal and regulatory framework which recognises the mutually reinforcing roles of discrimination, workplace and safety laws. Fourth, better workplace prevention and responses that are leader-driven and practical and adaptable. And fifthly, better support, advocacy and advice for people who experience sexual harassment. The focus of today's webinar is the legal and regulatory framework recommendations from the report. The 3 main legislative schemes that regulate sexual harassment in the workplace are the anti-discrimination laws, the Fair Work system and the work health and safety laws. We found that the interaction between these 3 schemes is confusing and sometimes inconsistent for workers and employers. However, we found there are significant benefits to each of these regimes, which are well recognised across Australia. So our recommendations are designed to strengthen and clarify these frameworks so they can work in a complementary and mutually reinforcing manner, guided by a sexual harassment council made up of the relevant regulators. We found that the Sex Discrimination Act, or the SDA, should continue to be the primary piece of legislation regulating sexual harassment at work and the anchor for consistency across the state and territory Equal Opportunity Acts and the Fair Work and Safety regimes. We identified a range of enhancements required to make the SDA and the Australian Human Rights Commission Act better suited to the contemporary experiences of work. These enhancements include clarifying that the definitions of workplace participant and workplace cover all people in the world of work, including those who are paid, unpaid, and self-employed and state public servants. Expressly prohibiting sex-based harassment. Expressly prohibiting creating or facilitating an intimidating, hostile, humiliating, or offensive environment on the basis of sex. Extending the Commission's discretion to decline complaints from 6 months to 24 months after the alleged discrimination took place. Consistent with other grounds of discrimination, allowing for representative complaints, and extending liability to those who aid or permit another person to sexually harass a person. Introducing a cost protection provision consistent with the Fair Work Act. Conducting further research on whether the current low damages reflect contemporary understandings of the nature, drivers, harms, and impacts of sexual harassment. And empowering the Australian Human Rights Commission to inquire into systemic unlawful discrimination, including systemic sexual harassment. To address our key finding that we need to shift from the current reactive complaints-based approach under the SDA to one that requires positive action from employers on prevention and better response, we've recommended that a positive duty be introduced to the SDA. The positive duty requires all employers to take reasonable and proportionate measures to eliminate sex discrimination, sexual harassment, and victimisation as far as possible, and would be accompanied by functions for the Commission to assess compliance with the duty and enforcement. We observed during the inquiry that many large employers assumed such a positive duty already exists, as it does in Victoria, and were keen to know what prevention activities would be successful. Our Workplace Chapter 6 addresses effective employer action on sexual harassment, which will be the focus of other webinars. A recurring theme that we heard through the inquiry was that for many victims, this was the first time they had told anyone about their experience and just been believed. And many years after an incident, they were still significantly affected by it. They told us they wanted their experiences to help improve the workplace for others. That's why we recommend the Commission facilitate a disclosure process that enables victims of historical workplace sexual harassment to have their experience heard and documented with a view to promoting recovery. To improve our national approach to discrimination laws, we made a recommendation for state and territory governments to amend their anti-discrimination legislation with the objective of achieving consistency to at least the minimum standard of the SDA. We heard that Fair Work is regarded as the central place for workplace grievances and a system that has been long and respected in this country. While the Fair Work Act covers grounds of discrimination, currently it does not expressly prohibit sexual harassment. Workers with multiple workplace grievances told us they wanted a simpler system to raise workplace concerns in one place. Employers told us that they got mixed signals from the Fair Work Commission when it came to sexual harassment misconduct, especially through the unfair dismissal jurisdiction. We therefore recommend a number of changes to the Fair Work system, including expressly prohibiting sexual harassment under the Fair Work Act using the definition in the Sex Discrimination Act, introducing a Stop Sexual Harassment Order equivalent to the Stop Bullying Order currently in the Act, clarifying that sexual harassment can be conduct amounting to a valid reason for dismissal in determining whether a dismissal was harsh, unjust or unreasonable, and including sexual harassment in the definition of serious misconduct in the Fair Work regulations. We concluded that Australian work health and safety laws already impose a duty on employers to prevent sexual harassment in the context of the broad duty to eliminate or manage hazards or risks to a worker's health, which includes psychological health and therefore sexual harassment. We heard through the inquiry that there is an urgent need to raise awareness that sexual harassment is a work health and safety issue. We therefore recommend that safety ministers amend the model work health and safety regulation to deal with the psychological health as recommended by the Boland Review. We also recommend that safety ministers support the development of guidelines on sexual harassment, which could be used to inform the development of a code of practice on sexual harassment. These guidelines and code of practice should use the same definition of sexual harassment as the Sex Discrimination Act. The events that have unfolded in the media and entertainment industry in the US, captured in books like She Said, TV series like The Morning Show, and movies like Bombshell, have placed a significant spotlight on the role that non-disclosure agreements, or NDAs, have in perpetuating sexual harassment. After close consideration, we determined that NDAs play a valuable role in protecting the privacy and confidentiality of parties and providing closure. However, I'm concerned that blanket NDAs also undermine prevention of sexual harassment by impeding proper scrutiny by boards and governance bodies, by preventing organisations learning from complaints and identifying systemic issues, and by making it easier for perpetrators to reoffend with impunity within the same workplace or beyond. Therefore, we've recommended the Commission develop a guideline identifying best practice principles for the use of NDAs in workplace sexual harassment matters to inform the development of a regulation on NDAs. Also topical during the inquiry were media reporting and subsequent defamation claims that involved detailed public evidence of sexual harassment allegations, sometimes without the consent of the victim. We heard that Australia's defamation laws discourage victims from making a complaint. In addition to their current review of defamation laws, we recommend the Council of Attorney Generals consider how to protect alleged victims of sexual harassment who are witnesses in civil proceedings, including defamation proceedings. And recognising the numerous agencies, tribunals and courts that may address disputes involving sexual harassment, we also recommend that trauma-informed education on the nature, drivers and impacts of sexual harassment be a standard component of training for judges, magistrates and tribunal members, as well as for fair work, safety and workers' compensation regulators. So this is the start of a new conversation. Our world has changed dramatically since our report was tabled in Parliament only 2 short months ago on the 5th of March. COVID-19 has presented new challenges in all areas of life, and that includes in the sexual harassment space. I'm concerned that rates of sexual harassment in the online world will increase, and I'm concerned that workers will feel even less empowered to bring complaints of sexual harassment in an increasingly precarious employment environment. The need to address sexual harassment has not lessened. However, the immediate priority for our government and many workplaces has changed, and rightly so. While the government's response to respect at work may now be delayed, I think you'll agree that workplaces and regulators have already, in our comprehensive report, the information they need to take action to create more productive, respectful and safe workplaces. So Kate, I now look forward to hearing your reflections on the report and your experience, and I encourage participants to continue to send questions through for Kate and I to answer after her address. So over to you, Kate.
Well, thank you, Kate, and thank you for that very comprehensive overview of the report. It's a lengthy report and I've read it all, and I'd certainly encourage all my colleagues in the legal profession to do so. So can I thank you and your team for the production of the report and the care that has gone into ensuring that the voices of all interested parties have been heard. The report is important for us as lawyers for 2 principal reasons. First, the role that we play in advising individuals, business, organisations and governments on the application and the operation of the law. We advise and we assist organisations on compliance and measures to prevent sexual harassment occurring in workplaces. But we're also there when things go wrong. And that is either complaints arise or very difficult incidents need to be addressed. And you've identified the three main areas that are relevant for the work that we do as lawyers: the anti-discrimination laws, the Fair Work system, and the work health and safety. The second area is that for the legal profession, we know that women in the law are subjected to sexual harassment, and we know the numbers in terms of prevalence of the experience of sexual harassment within the legal profession. And to this end, I acknowledge the work done by the Women Lawyers Associations around Australia, by our professional regulatory bodies, and the very substantial piece of work undertaken by the International Bar Association over the past few years on the US Too report. So my focus today is to take a closer look at the recommendations that are found in section 5 of the report. And for all of you following, the summary of the recommendations starts at page 43 of the report. And section 5 makes recommendations from recommendation 14 through to 40. But also it's important to read the recommendations in section 6 and section 7, which I think give a good context to the legal recommendations. So they're important to the work that we do as lawyers. So my comments will be focused on three areas arising from the recommendations. It's impossible in the time that we've got today to cover them all in detail, but I'll discuss them because I want the lawyers following this to think about these issues and perhaps to raise some questions. So the three areas I want to deal with is first, the amendments to the Sex Discrimination Act. Secondly, the enforcement mechanisms and the role that non-disclosure agreements play in the enforcement processes. And then thirdly, the question of training. So if I can start with the amendments to the SDA first. I was very heartened to see the recommendations in the report about the need for consistency between the state and the territory laws. In many of the submissions made by the legal bodies, they recognise that the inconsistency between state and territory laws resulted in some cases of coverage and protections against sexual harassment in some states and territories, but not in others. And likewise, the inconsistency between the protections in the Fair Work Act and the Sex Discrimination Act were a matter of concern. So it may be impossible to harmonise those laws for the reasons that you've discussed in the report, that the work of the Sex Discrimination Act is different to the work of the Fair Work Act in its entirety, and also different to the work health and safety legislation. But they have to work together and they have to work consistently. So one of the challenges for us as lawyers is to think about how each part of the three can serve better protections for employees against sexual harassment, but also to continue to ensure procedural fairness, both for the people alleged to have engaged in sexual harassment and the organisations that sometimes find themselves in the middle of difficult issues in balancing the rights and obligations of respective employees. So I was certainly heartened to see the suggestion that there be a consistency of the state and territory laws with the relevant definitions in the federal law. The second area, which I thought was an interesting recommendation, and for those following and reading the report, it's the discussion at page 457 of the report. You received some submissions about simplifying the definition of sexual harassment in section 28A, and also some submissions suggesting that that definition was perfectly fine and it should be retained. The upshot appears to be that the Commission has accepted that the definition of sexual harassment is clear and it should be retained. But what you also do is to identify where those grey areas are sometimes in the application of the definition of sexual harassment in section 28A. And these are in the areas where they may not be overt sexual conduct or conduct of a sexual nature, but sex and gender is playing a role in the harassment. And so the discussion about sex-based harassment and the discussion about countering hostile work environments, I thought was an extremely important part of the report in developing and assisting us as lawyers to understand the complexity of sexual harassment from time to time, to also think more broadly about how and when conduct that might not be directly of a sexual nature but nevertheless impacts on women in the workplace can be characterised as forms of sex discrimination. And I note the discussion that there needs to be some further work done in education in this area. The next point for the self-employed legal practitioners, and particularly the barristers, we very much welcome the expansion of concepts of workplace participant. So where, for example, as barristers, we slip between the gaps of protections under the federal law, that gap being, I think, closed would be very welcome. So the controversial issues, I think, coming out of the recommendations are going to be how the legal community responds to a positive duty and what that means when we advise our clients who have the obligation to prevent sexual harassment in the workplace. So I want to be sort of conscious about the onerous obligations that a positive duty may create for employers, and sometimes the difficulties for them in discharging their duty in relation to vicarious liability. I think there's a lot that we need to discuss in terms of workplaces about how a positive duty will work in practice and how a positive duty will start to change the cultures in practice in terms of the onus always falling on the complainant to have to initiate complaints or address conduct. I think there's a big cheer that finally the hiatus in the way the Sex Discrimination Act operates around accessory liability has been fixed. It's been my personal view that the exclusion of the accessory liability provision in section 105, which is aiding, abetting, assisting, permitting sexual harassment, was never a deliberate act by the Parliament to exclude accessory liability work in sexual harassment cases. And so again, fixing that little anomaly or hiatus is welcome. And likewise, some clarification on how victimisation operates and whether that can be addressed by our courts from a jurisdictional perspective is important, not only for the Sex Discrimination Act, but also more broadly for the whole of the anti-discrimination laws. All right, in the time that's remaining, I want to touch on enforcement and training. The discussion around enforcement is also very important for us from a practical perspective. We know that many women either make no complaint at all, or once the complaint process starts, the experience of navigating a complaint process can often be as bad or as traumatic as the underlying harassment. We know that there's a burgeoning business in workplace investigations. And what we've seen often is that investigations which are intended to help employers make fair decisions by ascertaining the facts can often only compound the problems both for a victim of sexual harassment but also the person accused of engaging in sexual harassment. So concepts such as the Briginshaw test, what level or standard of proof should apply to investigations. I think your report takes cause for a pause on when and how and why we use investigations in the workplace. Should it just be automatic, or should there be some other options available to deal with complaints? To me, reading the whole of the report, it reinforces the need for us as legal practitioners to start to better understand a trauma-informed approach to the work that we do, and to think about the impact of trauma on people who are the victims of violence in terms of reliability as witnesses, as credibility, but also to have some sensitivity about when and how people may open up about traumatic experiences. And so I very much welcome the discussion about trauma-informed and approaching these matters in a sensitive way. With respect to representative claims, I read that with interest. There's a real, I think, appetite for representative and class action proceedings in employment law. I've only ever had one in my experience in sexual harassment, which involved, again, a solicitor who put a pinhole camera in the back of the toilet door of his workplace office, so filmed all the women using the bathroom. He was discovered because the tapes, as they were back in the day, were in a wheeling bag. No one knew the tapes, so they took them next door to the local video shop, who put the videos in, which were then circulated around all the televisions in the store and then sent everybody into a fury. In that case, it's my only ever case of a class action. We had 17 women who we brought the complaint against the perpetrator. So it's going to be difficult to have class actions in sexual harassment matters. Have I gone off the right? Is that working? I've switched myself off, but I don't think I touched it. Apologies, everyone. So I think that's going to be a very interesting issue on the representative proceedings. I very much welcome the idea of a workplace sexual harassment council. I think that that would be a very important initiative to help us bring together some resources, particularly around compliance and prevention. And I also welcomed your recommendations on industry schemes. And this is particularly important for us as legal practitioners, because we also have professional obligations. And I think you note in the report that the legal services bodies, both in Victoria and New South Wales, consider that sexual harassment will be a form of professional misconduct in certain circumstances. And that's an area that we need to look at more, but we also need to carefully look at the interaction between the SDA and also the interaction with the professional regulatory schemes. That's another area where you get some complexity. And finally, I want to touch on training. I've been following your work on training and also some recent work at the UN level, which examined why training programs that are now commonplace in Australian workplaces often are ineffective in either changing the culture or giving women the confidence of using complaint procedures. And so I think it's time to perhaps go back to the drawing board on the way in which we do training and thinking about what are effective training models. And recommendation 40, which is a suggestion of judicial training, that picks up the way in which the decision makers will deal with sexual harassment matters when they come before courts and tribunals, is very important. But that training cannot be done unless the lawyers who participate in the judicial proceedings and in the tribunal proceedings also share a common understanding with the judges and the tribunal members. So I probably think that recommendation 40 could be expanded out to the broader legal profession, particularly those with the responsibility of providing advice and assistance both to employees and employers in this area. So in that context, thank you very much for the report. It's generated, I think, a lot for us as the legal profession to think about, not only in discharging our work as advisors, but also the standards to which we hold ourselves to, and that we should lead by example in this area. Thank you very much, Kate, and I'm happy to answer any questions that may be coming through with you.
Thank you very much, Kate. That was really helpful, really practical, and of course from someone who is so well versed with the operation of all of those systems. So I appreciate that. So there are a number of things you've prompted, and I've got a number of good questions coming through. So I think, Kate, what we'll do is you and I'll ask the questions and then either sort of ask them of myself or you, and we'll kind of work as we go along. I'll probably do a first thing in that last two things that you said. One is when you say hooray, that's a really, after 18 months work, our whole team is excited to hear someone say hooray with what we came up with, because we definitely gave it a lot of thought. But also that last comment on the education and training for judges and tribunal members. actually we did really have a strong view that people who handle sexual harassment complaints, both lawyers but also HR people and people on the ground, really need that trauma-informed information because they are often the front line of the extra damage that you talked about. And so recommendations about that education sort of fall in the workplace chapter, saying anyone who's really dealt with or deals with sexual harassment in a workplace setting, which I would say safety, HR, industrial relations and legal people should be more well educated. So I think we got there in another way. So I've got a few questions, but I think, Kate, I'll start with my own question for you first, because I know you have been doing sexual harassment cases for a very long time, as I have, and you recounted one of them in your remarks. I just wondered whether you could tell me of your cases, what might have been maybe the most memorable sexual harassment case and why?
Okay, that's a hard question, but I think it's probably this one. I came to the bar 22 years ago and I was asked to go to do some consent orders in a sexual harassment matter, but it turns out they weren't consent orders at all. And I ended up having, as a very junior barrister, to have to run a very difficult sexual harassment case. My client was a teenager who had her very first job working for a GP up in a rural part of New South Wales. And the GP sexually harassed her from day one by requiring her to sew the button onto his trousers while he was still in them with his fly undone. So that gave you a flavour of what it was like. And her mum said to her, "It's a really good job, you've got to keep going." And so she was courageous enough to come forward and make a complaint and then to pursue that complaint. And it turned out that the CES at the time had known that this doctor had fallen. And through the discovery process, we found that I think there were 5 or 6 women who'd been placed by the CES into the same doctor's workplace and had also experienced sexual harassment. So that's a case that's now called Elliot and Nanda, which is the case that deals with Section 105 on vicarious liability and accessory liability. And so for me, it was a very steep learning curve, and but it also showed me the courage of a young woman to be able to take on a claim of that nature and be successful. So I learned a lot from her as a young woman, but I also learned a lot for myself in terms of thinking, what have I got myself into in terms of doing this work? So that's probably because it was the first big case that I had done by myself in the federal court that I remember that very clearly.
Fantastic. And I think that example, and for those of you who are younger than Kate and I, CES was the Commonwealth Employment Service, which is now Centrelink, just a translation. That case is really important, but also I think, you know, the legislation came in 84, and I think we did have some big cases early, but our inquiry really told us that in the last 10 years, people have just watched, I think they've watched the media, the stories, how brutal it is, and we absolutely heard that the incredible fear now. And I think there was, when I started practice in the 90s, there was a lot more sort of heart that this is going to make a difference. But I think the last, you know, as it's evolved with work changing, with people in not as secure work, with more gig economy, self-employed, you know, temporary work, people just don't feel like they can do anything as controversial as bringing a claim. So we definitely heard that the way the law has been used and exercised in the past is no longer happening, that people really are not doing that. So another question, which is just timely, is about, and perhaps I'll have a go and then you, is about how this report and inquiry that was launched right before the situation that we all find ourselves in with COVID-19 keeping us all in restricted environments, and often, except I think we can tell from you, away from our workplaces. I can see lots of law books, and I'm assuming they're not in your home. How do we think these recommendations are going to go in a COVID-19 world? And so if I start, and then I'm interested to see what you might think about that, Kate, or any reflections in terms of gender and COVID. My first, I really credit my team. We pivoted very quickly. We had 6 months of planning of international and local travel to share the outcomes of this inquiry, and also really a government that was saying we're very keen to look at the recommendations. They're still very keen, but their timing is different. But my sense is that this hasn't disappeared as an issue, and we heard through the inquiry the impacts, like the story that you've just told, the impacts are long term. They impact people, and particularly their ability to go to work, to reach their potential, but just to earn a living. So we haven't changed our focus, and I know in terms of my work, workplaces have started reaching out and started to say, well, what can we do to get these up and running while we wait for a more formal response from government? But in the meantime, I know my small team has started looking particularly at the broader gendered impacts of COVID, and I'm working with a range of different leaders of agencies across government and the Office for Women and DFAT on helping sort of map out the way forward to make sure that government recognises the gendered impacts of COVID. And we know straight away the industries that are affected, the ones that we really need to go out to the front line are female-dominated industries, the social assistance and healthcare industries, the teachers that we need out there. We also know as kids come home, the disproportionate amount of responsibility women have for that care, and we know the potential financial impact of how this will unfold and how it could impact women. So that's the other thing that I've very quickly, with organisations like ANROS and Our Watch and WGEA and eSafety, all of those agencies, the ambassadors that we have for gender working on that. How do you see gender sexual harassment in the COVID world?
Oh, okay, it's a really good question. I think on one level, it's changing our relationships, and relationships are often critical to understanding how my sexual harassment occurs. So I wonder, in a post-COVID world, that our sense of physical presence and our distance between people will change the physical interaction between people in the workplace. We've heard a lot about not shaking hands and not doing the elbow shake and the like. But I wonder whether there'll be more reservation in terms of literally touching people or greeting people that have had a gendered aspect to it. And so that may change, and that may have an impact on respecting people's physical space a little bit more, and that will naturally have an impact in terms of sexual harassment. But the other aspect around sexual harassment and power is understanding some gender dynamics as well. And I think perhaps families being at home, and for men to have a greater insight in what the private domain is like on an all-day, everyday basis, may well change the way in which we understand each other's perspectives differently, and whether that then has a long-term impact on how we work and our organisation around work. It's a little bit, let's just see. But what I've heard from a number of women's groups, and we've been talking about, is that what comes out of COVID is opportunities. Despite the horrendous tragedies that are occurring and the risk to our health, our families and the economy, there are opportunities. And I think the work that you're doing presents a good opportunity to reflect and think on what might be better workplaces that we can see coming out of COVID-19.
Fantastic. I'm looking at some of the other questions. So one I might answer quickly, which is, when can we expect a response from the government to the Respect at Work recommendations? I think that's hard to tell right now. I think we can all understand that government is focused on other things. So while we expect there will be a response, I think right now they can't give us an indication. We know the Attorney General's Department has multiple copies, is reading it, but it's also reading it around making other legal changes to allow what's happening going on. So the answer is we'll watch this space. We'll keep you informed. Having said that, there are a number of things in the inquiry. The other thing that I meant to comment is thank you, Kate, for quoting page numbers just to demonstrate that. So it is a very big tome, the sexual harassment inquiry, and I appreciate that Kate knows the page numbers, but I also do accept that the majority of people will probably enjoy this version a little better, and that is also an excellent read. It's called our community guide, but it's really a summary with all the recommendations in it that is very easy to dip in and out of as well. So great. So a question from Fiona Vines at BHP. She's asked, how might employers partner with the Fair Work Commission to develop a shared understanding of the structural changes needed to eradicate sexual harassment in workplaces? So thinking broadly about employers working with Fair Work, one of the great things about this inquiry that I found was that employers and the Commission, I talk frequently with the Fair Work Commission, everyone wants to get to the same place, and unions, of course. So thinking creatively and laterally, how could employers partner with the Fair Work Commission to move that along? Do you have any practical ideas? Because I do think it has a lot of opportunity.
Look, I agree, Kate. I think there's a real challenge in it because there's parts of the Fair Work Act that protect the rights of workers who lose their job. And if you're dismissed because of unfair dismissal, you're dismissed because of sexual harassment, then accessing unfair dismissal protections is important. And we see the Fair Work Commission dealing with sexual harassment from the perspective of a person who's lost their job for engaging in such conduct. But on the other hand, we have standards that apply to all workplaces. So national employment standards are really there to have a platform of protection for all workers. And there's no reason why sexual harassment shouldn't be included in those core protections. There's no reason why sexual harassment shouldn't be recognised, for example, as a species of adverse action. And so rather than try to sort of weave it into, for those who work with the Fair Work Act, dive into section 342, item B1, to make it clear that sexual harassment, and even if the Commission thinks that a broader view of harassment just beyond sexual harassment is appropriate, it could go in there. We've had a real debate about whether section 351, the discrimination protection, extends to sexual harassment. So some clarity around the existing provisions would be a good place to start. And then secondly, I think the work that you want to do with the Sexual Harassment Council is the place for those groups to come together outside the adversarial settings to work through how sexual harassment can be addressed through that Fair Work lens.
So that's a great distillation. That is, one, advocating for those changes, because as you graphically showed, what we heard was exactly that. People do get sexual harassment cases, both employers and employees, into the Fair Work Commission, but it's tricky, and that we'd rather not have that. And the Workplace Sexual Harassment Council does, in its structure, have advisory members, and so employers, unions, employer bodies would definitely be excellent advisors. So that's another practical way. Going to some of the training and legal provisions. So Leah Marin, who works with the Australian Women Lawyers, has asked a couple of questions, so I might combine them and put them back to you. So one of them was whether organisations like Australian Women Lawyers or like the Law Council could be involved with training judges, and also what's the role of the professional conduct rules in looking at lawyers and sexual harassment. So do you have, I know you've got a hat with the Law Council as well, so do you have views on that?
I'm not speaking today with any law counsel or any official hat on today, so I want to be clear about that. I think in terms of the role of lawyers training the judges, that's something that's got to be dealt with sensitively. And there is the Australian Judicial College, which has a very extensive program in terms of training of judges, and that's really the first port of call in terms of any judicial training. But it would be helpful that if the judges and the tribunal members receive training, that the lawyers who appear before those judges are aware of the nature of that training so that there's a consistency in approach. And the Law Council may have a role in that, also the Australian Bar Association. And we also need to work with our professional regulatory bodies, so the Officers of Legal Services Commission. So I know the work that Lee has done with the Australian women lawyers has really highlighted the need for training. So when I said earlier, going back to the drawing board, I'm not suggesting that we dismiss everything that's come before, but that we take what you've got in the report and some of that recent work and research by the UN to say, how do we sharpen up our training, to ask what is its purpose and how do we make it effective?
So adding to that as well, Kim Rubenstein of the 50/50 Foundation also, just talking about that training point, said, would we also say that training should go even more broadly to law schools and to teaching of legal practice? What are your reflections on that? Because I know, as someone who's a practitioner in this area, I know you apply trauma-informed approaches. I know in the report, in the workplace section, I did some work with the AFL, and there's a case study on them using trauma-informed, victim-centric approaches to their complaint management. And I always remember their head of integrity saying that that approach just was revolutionary for them. Suddenly, things that were really impossible to solve became actually much easier to handle. So it's not just sort of thinking of the victim, it actually makes the problem sorted easily. So, but as lawyers, we're not trained to think trauma-informed. What do you think about Kim's question of going into law schools?
I do think in law schools that would be important, because trauma-informed is not just specific to sexual harassment. It helps us understand our clients when we act for clients who have suffered trauma, be it in a torts-based concept, be it in the criminal law, victims of violence, and in family law. So understanding a trauma-informed approach is relevant, I think, to so many areas of practice. And I think for lawyers, sometimes we think trauma-informed is that we're being too soft or it's fluffy, but it's not at all. It's actually about understanding why and how people respond to events, what triggers people on certain things, but also finding ways of communicating with people. When we train lawyers in mediation, we sort of say, you've got to try to stand in the shoes of the other person and walk in their shoes, because if you understand their perspective, that will help solve matters. If you have not had trauma-informed training, it's very hard to stand in the shoes of a person who's experienced trauma and to genuinely look at issues from their perspective. So I do think that's a good idea, but I'm also conscious that the curriculum is very full, and so where the time and the space is to add these things in, it will obviously be challenges for universities.
So I might go from that to something that's just come through, which is about, it's connected to the trauma-informed and the victim-centric approaches. The question is, what are your thoughts on informal reporting processes, considering only 17% formally complain? So if I just do an opening description of what we found with that, there's no question that we found. So we're talking about the law reform, and I'm absolutely adamant that the law, whilst not used a lot, absolutely sets the underpinning of everything that we as a community say is okay. And even if no one ever uses it, the fact that the laws are there drive behaviour and influence what we prioritise. So the legal recommendations, if we would change how we engage, then we wouldn't need the legal recommendations, but they're there. But as we went around over that 18 months, but particularly in that intense consultation period, it was really clear that most people in workplaces told me that sexual harassment's very common, but I don't have options. It's either nothing or atomic. I can either do nothing or I can make a complaint and it becomes a thing. I'm suddenly in kind of a sausage machine and I'm one of the witnesses and I have to do all these things. And so there was very strongly a view that we don't want to be sexually harassed, but most of the things we don't need a full investigation. We just like someone to be told that's not an appropriate comment. You know, it's often the bloke I work with all the time who I mostly like. I don't want him to be disciplined, but there seems to be both legally in workplaces and also socially now this inability to say, hey, you know, that was not a very nice comment. Everyone's sort of, you know, a bit scared of all that. So in the workplace chapter, we do, which really very much is a part, the responding part is very much the lawyers should be reading it. We do say, okay, when you get the issue, do you have to go straight to that full investigation? So the question really was about what do we think about the informal processes? And you might tell if you read the report, but also just from this, is that my strong view was we need a lot more informal processes. We need, and I even don't like the word informal because formal sounds like that's a real one and informal's not a real one. So we talk about the anonymous reporting, we talk about different mechanisms that different organisations have put in place to allow lower level that doesn't get you into the big system. Have you got thoughts on that in a practical workplace sense?
Well, the first thing I'd say is there's a no one size fits all. And I think the danger is sort of taking a policy or a process off the shelf and saying that's right for my organisation. I think there's a step back from starting with formal or informal processes. And that is for organisations to say, what are our values and how do we value our people and how do we expect our people, our employees to work with each other? If we're going to have policies and set standards, then rather than have them on a sheet of paper and we have a great launch one day and then we forget about it and someone says, oh, didn't we have a sexual harassment policy? So rather than just have the policy and leave it, you want to try to avoid people having to go into a process. So that comes back to our values of how do we want our organisations to operate? How do we want to make sure that we're consistently through our communications, through modelling behaviour, modelling the right behaviours in workplaces? And if the values are working well, and you give people the tools to be able to resolve issues by having the difficult conversations with each other, or people supporting others to have those difficult conversations, to sort issues out and nip them in the bud, so to speak, that's preferable. Because often most sexual harassment cases in the workplace start with minor trivial things that may or may not even reach the definition of sexual harassment, but they're annoying or they're creepy or they make you feel uncomfortable. And often it's over time that the problems then become a problem where it has to be reported. And then, as you say, you're either going into an informal report where the answer is, unless you formally report it, we can't action it. That's not helpful. Or you're into something fairly significant in terms of an external investigation, which can often be as traumatic as the original sexual harassment. So I think it really fundamentally comes down to organisations asking, what do we actually want our workplace to look like? And how can we achieve that in providing safety for people to be able to raise issues as they need to raise them? Now, some listening to this might say, that's Kate being a little bit Pollyanna. And on one level, it may be, because I'm not undermining the importance of having formal processes, to have the option of going to the police, and also to be able to take legal action to get redress and to receive compensation in some circumstances. But the starting point seems to me about how we manage workplace relationships, and a focus on that rather than the processes would be the starting point. And then think about the process that you want for that particular workplace.
Fantastic.
Easy, Kate. Easy.
Okay, so I've just gone and grabbed my 1995 certificate that said I developed the first sexual harassment. So that's not that good anymore. That didn't do it. Didn't fix it. Okay, I've got 3 more questions, and I think we've got a time for all 3 of them, which is good. And apologies if I haven't got to everyone. So this one's got a lot of legally facts in them, so I'll read it to you. It's from Kiran Pender, who's at the International Bar Association and who did that wonderful survey and research us to on the global legal experience. So he said, for several decades, typical non-economic damages for sexual harassment in judicial decisions were in the range of 10 to 20,000. The 2014 decision in Richardson increased that to 100,000 or above. Is that enough? Has it changed employer behaviour in preventing workplace sexual harassment? Do courts and legislators need to revisit sexual harassment damages in the Me Too era? So I might start and then get your reflections on that. So one of our recommendations was specifically that more research be done on the sexual harassment damages awards to see whether they reflect the contemporary understandings of the harm of sexual harassment and also the messages that the community wants to send about that. And we didn't come up with a specific recommendation about it because in the course of the inquiry, it was wide scaling and we didn't feel like we could do justice for that piece of work. But if there's someone watching who is interested to get some momentum about doing that work, we would absolutely welcome that. But in particular, the contrast that was really obvious to us was the relatively few decisions and small damages awards in sexual harassment cases, but during the course of our inquiry, the astronomical awards for defamation, where someone was perhaps accused of sexual harassment and the harm that they might have suffered for being accused. And that contradiction, that complete disparity did suggest that that people who are accused of sexual harassment were terribly harmed, but people who had been sexually harassed, their harm was trivialised. So that was the reason for that recommendation. Any comments, Kate? And then I'll go to the next 2 questions.
Okay, so on that, I am aware that there is some research being done at the present time to look at the full court's decision in Richardson and Oracle to ask whether the approach taken by that full court in assessing general damages, that's damages for hurt and humiliation, not general damages for the loss of income or the loss of opportunity, has been widely adopted. And I think if one looks at the case law, there are not a lot of cases where the general damages component has been as high as the Richardson case. So this raises a really difficult issue for me, because what I can tell you is that the majority of strong, substantive sexual harassment claims that come through a commission process or otherwise, that then make their way through conciliation or into private mediation, that the damages that might be the result of a mediated process are significantly higher. And you can add a 0 in some cases to the Richardson and Oracle 100,000 to get an indication that, damn it, there are resolution of private matters that are confidential where the sums are significantly higher, very significantly higher. So this is sort of where there may be a skewing of the system, is that the sorts of matters that often end up in court are matters where the parties haven't been able to reach an agreement because one side or other has overly high expectations or unrealistically low expectations. But my experience has been over the last 15 years in particular, is that the case law has little bearing on how matters are settled in private mediation. And so this might come to the NDA issue, is that this is the trade-off, is that the amounts are higher, with the trade-off of the confidentiality versus the lower sums that you may see in some of the tribunal matters. So 100,000 is still a very high amount for a court to order. So it's quite a controversial area, and for those who regularly practice in the area, we're familiar with 100,000 being raised, but it often is raised, but it's not our starting point or our end point. Yep. So I do think some further research into this area would be helpful, and I do think there are issues of equity in terms of the sorts of ranges of general damages that come up. But ultimately, I say, as with anything, is that you have to prove loss and damage, and there has to be an evidence base behind any loss and damage. We're not in this jurisdiction punishing people, and so the damages awards are not paid as punishment, they're paid to compensate, and that's going to be a case-by-case basis as well. But my primary point is, just because that's the public doesn't mean that it's the same in terms of the private resolution of claims.
So hoping I've got all my the two last questions, I might, given the time, I might have a go at them myself. So one of them is from Jess Verheely, who's Larissa Waters' advisor, asking, the Human Rights Commission has previously considered amending Section 13 of the SDA to allow the Commission to deal with discrimination claims relating to state agencies. Is the recommendation for better harmonisation of Commonwealth and state discrimination laws intended to address this, or is amendment of Section 13 still being considered? So our recommendation, which was to include the public servants, the current exemption of state public servants be removed, is specifically to include state agency, state public service in the federal legislation. So we found in looking at that workplace provision that it worked in fits and starts for depending on who you were. And I note that just this week I received a note that in South Australia they are also looking to make sure explicitly that politicians are covered by the legislation as well. The last question that I was going to have a go at, but also recognise that we will have several sessions specifically on workplaces and employer responsibilities. So I think the NDAs will discuss more there as well as this, was about preventative measures. So requiring employers to take reasonable preventative measures, and how do we define that? So that is really at the heart of what we're asking employers to do. And there's a couple of things. One is we're looking to produce guidance, and I know in Victoria, where they already have a positive duty, they will soon be releasing some guidelines for employers in Victoria. So Kristen Hilton, who's the Commissioner in Victoria, is in the process of developing those. What we found is employers have been doing almost things that they would have thought were preventative measures, often to meet that reasonable precautions defence provision. But a lot of our workplace chapter is to really bring people up to a contemporary understanding of best practice, and to recognise that some of the things that we've historically thought were prevention were really more like compliance and risk self-defence kind of mechanisms. Just simply having that pretty policy, ticking a box about the training, and then doing a complaint, dealing with it in a really legal way. They were believed to be the prevention. So I guess this is please come back to one of our other sessions. I also think that conversation, I want to have a whole other conversation with you about why settlements are so high. As a lawyer for large employers, I don't think they were ever high because there was a view of the harm. I think they were high because of the fear of reputational damage, and that intersection has been an interesting evolution over time. So what I'd like to do at this time is say thank you to everyone for joining us. Thank you, Kate, for coming along. Thank you for participants for all your questions, and I encourage you to promote the inquiry, to share the recording of the webinar, and to join future webinars. Particularly thank you to my amazing team, Amy, Georgia, Claire and Lauren, who turned on a dime and have just started becoming webinar producers in no time. And in particular, I just want to encourage everyone to remember that whilst our report might be big and sexual harassment might sound complex and the laws might be complicated, actually it's really simple. We simply don't want sexual harassment at work. It's not inevitable, it's unacceptable, and it can be prevented. And I really appreciate everyone joining the webinar to hear us talk about that. Thank you very much.